Dear students, this is chapter 2 about formal institutions, political, economic and legal systems, and what the impact of these formal institutions is on the success of doing business abroad. So we will tackle economic institutions, second political institutions, and third legal institutions. So what are the learning objectives of this chapter? So after having heard my recorded lecture and after having studied this chapter, you should be able to explain the different concepts, the different institutions, and the key role that they play in reducing uncertainty based on a transaction cost framework, which I will explain, which is not explained in the book. Second, we will look into the differences of political systems. We will talk about democracies and the likes. We will explain the systemic differences between economic systems, and there we will talk about market economies and command economies and variations, of course. Fourth, we will explain the basic differences between the legal systems, common law, civil law, and what are the implications for you doing business in a foreign country. And then I will discuss 3 important debates where I expect from you to have a qualified view on them. For example, how do you, as a company, protect intellectual property rights? So then that will enable us to answer the questions on an interesting case, a Repsol case, a Spanish company which was expropriated in Argentina during the Kirchner regime, and what are the consequences for this company. I followed the case in the European Parliament and at the think tank ACP in the Wetstraat, Avenue de la Loi in Brussels. And then we will look at the implications for action if you are in a company as a management trainee next year or the year after, and you need to do business development for a certain country. How do you proceed? So a first interesting opening case that indicates the importance of politics and political influence on successfully doing businesses in a certain country. Look at Turkey. And managing business risks in Turkey is not that easy. There were a major milestone a few years ago was the agreement that was signed between Turkey and the European Union in 1988 to reduce and phase out import tariffs between the 2 blocs. And that resulted in a customs union in 1996. Now the protective barriers were, of course, removed. Tariff barriers, non-tariff barriers, and the industry was exposed to dramatically more intensive competition. So Turkish exporters and Turkish importers increased their trade with the European Union, and some Turkish businesses, for example a company like Beko, were able to use the customs-free access to the European Union to develop major market shares and major market positions. Now, in 2003, the Justice and Development Party won parliamentary elections in Turkey, and Recep Tayyip Erdogan became the prime minister. Now, under his leadership, Turkey advanced economic reforms, not only stabilizing and liberalizing the economy, but also aligning the regulatory framework with the European Union. Now, the Western European companies considered Turkey at that time as an attractive location for business. Some companies like Fiat from Italy, Renault from France, De Koning, a Windows producer, from Belgium, they entered Turkey and they took over companies. Now, despite the praise for a predictable environment for business and an annual economic growth at that time of almost 4% in real terms, many potential investors were still concerned about the country because the policies of the AKP government gradually shifted and the political situation changed towards value conservative policies such as promoting traditional family values in Turkey and large size families. They began in Turkey to restrict entertainment businesses and tighten regulation on alcohol consumption, for example. And added to this were restrictions on the access to the internet, including temporary bans on Twitter, for example, and YouTube, and a general perception that Erdogan was acting increasingly like an autocratic leader. Now, there were power battles, the unhappiness of the secular urban youth with the policies led to extensive demonstrations back in 2013, demonstrations around Istanbul's central Gezi Park in the spring of 2013. And so as a result of this, a company like Diageo, and the world's largest distiller that had acquired a Turkish local distiller, had some problems because they were a maker of the famous Turkish liquor raki, that is very traditional in Turkey, and because of the ban on alcohol, of course, and alcohol advertisement, there were some problems of this company still operating in Turkey. So this is the situation as it is for Turkey. So a change in the political situation and a change in the legal situation had an important impact on doing business in Turkey. So the protective barriers were removed, Turkish exports and imports took off in the beginning. Now, if we look at data of institutional reform and the institutional environment in Turkey, we will perceive that it is less sophisticated than some of the European Union members, such as Spain and Italy, but more sophisticated and compared to other emerging economies, such as Russia, India and China, it's more advanced, and it showed at a particular time promising developments on several dimensions. Let's look at these dimensions, because these are interesting data that you could gather also if you want to have an idea about the institutional environment of some countries. So if you look into quality of education, for example, then you see here in the table that the quality of education is quite good in Turkey. These are data that the INSEAD, business school in Paris, gathers. So it's Global Innovation Index data. And in fact, Spain is of course more advanced, but when you compare to, for example, India, Turkey is at a higher level. And it's also comparable, for example, even higher than a country that is an EU member like Romania. Now, the quality of technology infrastructure from the same databases gives also a nice idea. So how advanced is the infrastructure, technological infrastructure in Turkey, and then you see that it's quite advanced, that we see that it's actually at the same level of countries. It's a bit higher than India, so it's of course not there yet. It's not at the same level as China, but technological infrastructure is not low, and there is a positive evolution. Openness, effectiveness of markets is also important, because when you want to do business with the country, when you import and export your goods, it's important. What is an interesting one is data that you can retrieve from the Doing Business Index of the World Bank, where you see how much does it cost and how much time do you need of a procedure to start a business in Turkey. And that's quite effective. It's higher than in China, it's higher than in India, it's a bit less efficient than in Russia, but you know, they are on a right track. So here the 61 for the procedure to enforce contracts is a bit lower. Then you look into the data on legal protection of minority shareholders, because that's important. If some shareholders of your company would be expropriated, which is an extreme case of course, but there needs to be a protection of shareholders when operating in Turkey. Transparency International is actually Göttingen University in Germany, which gathers these data on corruption. So is there absence of corruption? So of course the higher the better. So then you see that in Spain it's quite okay, but in Turkey it's on a right track. Now then you see constraints on political power, and there Turkey is not scoring very good yet, because there is a lot of problems with interference of political power in the business world. Now these data you can retrieve if you like, and if you need it for master thesis, for example, from the Polcon index. This is an index which is also from 0 to 100, so 100 is the best one, 0 is the weakest country. Now, I would like to give you a second example as a kind of introductory case, because this signals what we are going to discover and to learn in this chapter is an illustration of the impact of legal changes on successful internationalization. And there a nice example is what happened in South Africa, for example. In South Africa, you had the ANC related party, which was established by Nelson Mandela at the time, and in the past, of course, white people were the majority in South Africa, and they were the people that were involved in business, and there was, of course, no emancipation of the black part of the population. Now, they introduced what they called black economic empowerment in '94, and as a result of this, there are different measures taken and different changes in the legal situation, which I added here at the right-hand side of the slide, where you see that 25 to 50% of equity is needed to be owned by black people from the black economic empowerment legislation onwards. So black ownership was increased in companies. More black-owned firms could be involved, and that was also a legislation which spurred the involvement of black people in big contracts. Third, the unions, which are very important in South Africa. If you think, for example, about the mining industry and extraction of raw materials, unions had enormous power, and unions could block layoffs of black people. There was also some legislation which changed this. And there are 48 million people, that's the population of South Africa. Now the unions are very powerful, and there are a lot of black workers, and to block the layoffs, there was legislation in place. Now, access to government contracts is also an important one, because in the past that was a privilege of a lot of the white part of the population. So this has, for example, implications for a company such as South African Breweries, which is owned by AB InBev, which is a foreign company. So they needed, in the dispersion of their ownership, there is a part of the company that was it was in the hands of the South African Brewery Foundation. 40% of the company actually is owned by the workers, 9,000 workers, mixed race, and a part, 10% of equity, is part of what we call the South African Breweries operations. So a lot of important changes by the African National Congress, the ANC, when they came into power, and that of course had implications for companies doing business and operating in South Africa. When we look into the institution-based view, I need to tell you about the transaction cost theory. In fact, this is a transaction cost framework. Transaction costs are all the costs that are associated with economic transactions, the cost of doing business in a country. Now, that's blood, sweat, and tears to set up a contract, to negotiate with the local counterparts. Now, the transaction costs, actually, when do they increase? Well, there are three reasons why transaction costs increase, and that has to do with three characteristics of transactions. First characteristics is uncertainty. Second is asset specificity, and the third is frequency of the transaction. So first, if you think about it, so the more uncertain the transaction is, the higher the costs. So that means that, in fact, when your political, economic, or legal situation of the country is constantly changing, like in South Africa, like in Turkey, for foreign companies, it is very important to see that transaction costs will increase. So because of the fact that they don't know what the law, for example, on taxation or the law on employment contracts will be a few years later or a few days later. So that increases transaction costs. Second, if you have specific assets, if you bring to South Africa, if you bring to Turkey a patent, intellectual property rights, then the problem is, will they be respected? Because you have a specific asset, so that means that your transaction needs to protect these specific assets. This brand cannot be exploited. There cannot be copies of your software. There cannot be copies of your t-shirts and the likes. So the more specific the assets that are involved in the transaction, the higher the transaction costs, and that means that some companies will refrain from doing the transaction, which is a pity if you could have done interesting business in that country. The third characteristic of a transaction which increases transaction costs is the frequency of the transaction. And for the frequency, it's the other way around, in the sense that the less frequent a transaction is, the higher the transaction costs. Because if you deal with your counterpart in the country only a few times, then you need every time to sign a new contract, because you cannot sign long-term contracts because you haven't seen these people in a while. So the more frequently you interact with your counterparts in such a country, the higher, the intenser the relationship will be, and the higher, the less high the risk is, and so the transaction costs will be lower. What happens, that is all pre-contractual. Of course, after you have signed the contract with your local counterpart, there is also the risk of opportunistic behavior. So that means that your partner doesn't do enough effort, doesn't deliver on his promises, and so there is this act of seeking self-interest with guile. Now, even if you start your own e-commerce and you don't move, and you have your own only a home-based business, you have transaction costs. So this transaction cost reasoning is valid also for domestic business as it is for foreign businesses. Now, what are the dimensions of the institutions we are going to cover? Now, in this chapter 2, we are going to cover formal institutions, and formal institutions are normally inspired by the government. That's the political situation, it's the economic situation, it's the legal framework. The informal institutions are not set by the government, because this concerns how you behave as a manager, as an individual, or how you behave as a company, and how your behavior is then morally right or wrong. So this has to do with ethical behavior. What is important and what is not important in your society. So in fact, when we are talking about formal institutions, we are talking about laws, regulations, and rules. If you are talking about informal institutions, it deals with norms, and what you should do, with culture, what is accepted. Do you greet people by exchanging cards, or do you shake hands, or what do you do? Is there gender equality in meeting with teams of other companies, or is it preferable to go with men only, or whatever? So the ethical behavior. Now, if you think about it, in the financial crisis of 2008-2009, that revealed, in fact, that banks were, they made a lot of mistakes in their risk management practice. The question is whether they were aware of these mistakes, whether they were aware of the fact that they needed to have a buffer and they needed to have enough funds to be able to borrow to less credible borrowers, right? To lend money to less credible borrowers. Did they know this? That's a cognitive aspect. Or did they know that it was required from a bank? Or were they risk lovers and did they take too much risk instead of being the conscious pater familias in a bank? Now, in fact, when you look at it deeper, it emerged that in 2008-2009 that there was a combination of what banks should do and where they knew what best to do. And some banks had to be saved by governments afterwards. And the question was, were they behaving in a non-ethical way? Did they know? So it was the people from asset management that needed, and from the services of the bank, the study services of the bank, that were scrutinizing this, because too much money was lent out to people who were not credible. Now, the problem is not the institutions, and we will tell about the changes in the law, the changes in the economic system, and the changes in the political system. The problem is that these institutions are not stable, that they are constantly in transition. So that is the problem. And the problem is that a company can know the law, can know how taxation works, can know how to sign employment contracts now, but in a few years or a few weeks from now, the local government decides to change it, and this has, of course, enormous implications for foreign companies, and they don't know the informal rules of the game. So the institution-based view holds that successes or failures of companies are enabled by, and they are enabled by institutions, but they are also constrained by institutions. If these institutions, if the political system changes, then of course it might be the failure of a company because the company didn't know it. and is not behaving according to these rules. Formal institutions, we are going to talk about laws, regulations and rules, norms or values, beliefs held by people, and actions taken by people. Now, if you saw that the law can be made respected by the police, by the arm of the law. So you have governments that can punish people if they trespass the law. The problem with the informal institutions that is if you don't behave according to norms or beliefs, and you don't have a legal situation, you don't have a punishment by the lawyers or the judges, you need to use regulations, and you cannot have regulations that's coercive by a power of government, but you have only norms and cognitive pillars. So you are supposed to know how to behave ethically, and that these are norms, these are mechanisms through which the norms influence people, but you cannot punish them for not having respected the culture of the local people in the country that you operated in. And so it's not so for the law, for laws you can have a punishment, for norms you can't. The same is cognitive pillar, so that means that there are taken for granted values and beliefs. Well, in fact, before you go to a foreign country and you have, as an expat, and you go there, you should study it, and that's a cognitive pillar. You should study how to adapt to Chinese culture, how to adapt to Indian culture before you go there, and that is necessary for an individual manager. It's also necessary for a firm as a whole, and because there is this not nice behavior of saying, when in Rome, do as the Romans do. Now, that means that you are always adapting to the local culture. That can be like behaving like a chameleon, that you don't have your normal your norms and your limits of what you as a company will call ethical behavior and what you don't call ethical behavior. So you have to set your limits on your own. Now, what do institutions do? The key role of the institutions is, of course, that they reduce the uncertainty, as we said, in a transaction cost framework. So that uncertainty, of course, increases transaction cost, and the institutional framework can reduce also after the contract has been signed, when there is a good legal framework in the country that will refrain your counterparts to show opportunistic behavior by explicitly establishing the rules. So the legal framework in Turkey, the legal framework in South Africa is not static, but it helps, if it improves, it helps for you as a company to establish relationships with local counterparts. What is interesting to know is, of course, that especially in emerging economies, one of the typical characteristics of emerging economies, like we defined it in chapter 1, is that these are economies that undergo fundamental changes that are introduced to the formal and the informal rules of the game, and this is happening as you do business. So that means that you cannot expect that it's stable, but you see that it is in transformation, and you need to cope with this. Doing business is coping with uncertainty and coping with transition. Now, what is interesting are the two following core propositions in the institution-based, that are typical of this framework, of this theoretical basis of the institution-based view. First proposition is that managers and firms, they rationally, you can assume that they are rational and that they pursue their own interests. They want to make money, they want to increase their market share, and they make choices within the framework, the formal framework of the legal framework, political and economic framework, and the informal framework of the norms and the beliefs that they hold about the country, or that they think that people in that country hold. A second proposition is a qualification of that first statement, and is interesting because we know that there are many countries in which the political and the economic and the legal framework don't work. For example, if you do business in Africa, some countries in Africa, Congo, former colony of Belgium, there is a transition of these frameworks. Now, that doesn't mean that you cannot do credible business in these countries. For example, La Lorraine, a bakery firm, if you think about KBC, a Belgian bank, they are operating again in these countries. Now, the problem is that the formal institutions are maybe not working, but in the situations where these formal constraints are unclear, legislation is not perfect yet, or they fail, you see that the informal networks with your partners, with your joint venture partner, informal constraints will play a larger role. And so, in fact, the trust that is existing between you and your business partner will compensate the fact that there are no legal strict rules in the country. And so this chapter will focus on that, but the second part, the second proposition is an interesting one because it sees that it tells us that we can do business also in emerging economies or transition economies in which there is difficulties in establishing, in knowing what the legal situation is. As soon as you have a partner, as soon as you know what the norms are, you revert to them. Now, if you start with a political system, political elections have an enormous influence on doing business. If you think about it, the situation in the US or the situation here in France. In the US, you have, of course, companies that do donations to political parties, to either the Republicans or the Democrats, and that's maybe not a very ideal system, but it's a kind of system by which companies try to influence political decision making, of course. Now, vice versa, before elections, political elections, these companies try to do that. Even in other countries, it is important for business. So even not in your home country, but companies typically, they are active in 70 or 100 countries in the world, and of course they want to influence the situation that so that it's favorable for their operations. Now, because they affect the circumstances for doing business, of course. Now, if you think about the UK, this is a polling station in the UK. Now, we had in 2019, we had the important elections about the Brexit and about migration. These were typical themes that were raised and that played a role in the outcome of this election. Now the question is, how are votes in a country, how are they really translated into political power? And we will study 4 types of democracies because we'll see that there are different systems, and in fact they have an enormous impact on the number of parties, political parties, that are represented in the parliament of a country, and as a consequence of that, of course, the ministers responsible for taking decisions approved by these parliaments, assuming that these countries are democracies. So we will look into the types of democracies and what the relationship with the companies are. So first, if we look at the political system, what is a political system, of course? That refers to the rules of the game, the rules on how a country is governed politically. Now, political risk is the risk that is associated with changes. We went from, Emmanuel Macron started this idea about a new political party, En Marche, and that was changing the political landscape in France enormously. These people had no political experience, they had no relationships with companies, so all these things had to build up again. In the US, you have the donations, so you know the transition between George W. Bush 2003, then we had Barack Obama, and then we had Donald Trump, so twice a Republican, being Donald Trump and George W. Bush, and in between we had Democratic, Barack Obama from the other party, of course. So the transition, the political change in the US, of course, impacted not only the US companies, but also our European companies doing business in the US, or Asian companies doing business in the US. Now, if we look into what type of democracies we have, let's first start with the first distinction, which is a distinction between proportional representation and the first past the post system. You can look, after my lecture, you can look into the video, the embedded video on the UK system. And you discover, I happen to be the director of the Leuven Center for Irish Studies, which is European studies, of course, and we scrutinized the election results, for example, in Northern Ireland, because this is a part of the UK and it's important to see how this evolves. But what you see is, in some countries like the UK, you have this first past the post system. Now, this system means that there is not an equal representation, that not the ideal in continental Europe is that all voters are equally important in choosing the country's leaders. Now, in a first past the post system, also I have to mention that the European continental system is also not the ideal system, because there are some problems as well. But in a UK system, you have the first past the post, so that means that you have a minimum threshold that you need as a company, as a constituency, to have the majority of votes for a certain party. In the UK, there are not that many parties. There's basically the Tories and Labour Party. Now, why is this? Because each constituency in the UK elects only one representative, and the representative chosen is the one from the party that has the highest number of votes in that constituency. So you are either from Kent or you are from Yorkshire, and you as a member of parliament are representing either the Labour Party or the Tory Party. There is a small party which is called the Lib Dems, but it's not that big. You need a threshold to be able to have representatives in Westminster, in the Parliament. Now, also in continental Europe, there are parties that have minority shares. For example, they have to attain in Denmark 2% before they can enter the Parliament, 4% in Sweden, 5% in Germany. So that's kind of a threshold before you can enter the Parliament. And for example, in Belgium, you have the N-VA party, which the new Flemish alliance, which entered the European Parliament with only one seat some years ago, and then it was the first time that that party was elected. And in fact, the former Prime Minister of Flanders was the only one representative of that party, and then gradually they grew. But you see that there are, mostly in Belgium and France, you have coalition governments, because there are many parties that have people being elected in the parliament. Not the case in the US, which is not the case in the UK. Now, a second distinction, a second way by which you can classify democracies is to make the distinction between the direct and the indirect election of governments. Do voters elect representatives, or do they, like here with our pictures of Emmanuel Macron and Donald Trump, can they directly elect the president? And that is the case in France, that is the case in the US. That of course makes the direct link between companies and families and these presidents quite important, right? Whereas in other countries, in Germany, in Belgium, it's an indirect system, so they elect representatives, and these representatives only, they are in the parliament. Third way to make a distinction between democracies is the representative versus the direct democracy. Then we have to think about countries like Switzerland or the East cantons in Belgium, where you have an experiment currently going on with direct democracy. That means that the people, the citizens, can vote in certain referenda, where the opinion of the people is asked rather than the opinion of the parliamentarians that are elected by the people, that are representatives of the citizens of a country. And then the fourth element, the fourth way to distinguish democracies is to make the distinction between centralization and decentralization. So many countries, like for example the Federal Republic of Germany, it's a federal state, so that means that you have the national, Bonn used to be the capital, a very unimportant city compared to Berlin. So in fact, you have the federal government, and on a lower level you have the state governments of the Bundesländer. So you have many of them, and in fact there is a lot of decisions that are taken decentralized, so power is decentralized in states. In Belgium you have 3 states, and for culture you have 4. But it's interesting, so some countries are very centralized, like for example France, and you have the département, of course, but a lot of the decisions are taken in Paris, whereas in Germany this is not the case. And when you happen to live on the border of 2 states, you see the difference, for example in education policy, in a lot of legal issues, that you see that there is a difference in one state compared to another, and that can be difficult if you, for example, live in one state and you work in another. Totalitarianism is the other extreme. These are countries like Belarus, countries like North Korea, where one person or one party exercises the absolute political control over the population. A country like there are in the past, of course, the communist countries had dictatorships of a party, not of a person, but there are hardly any countries left with such regimes. And maybe Cuba, but Cuba also, there is a change in the regime. Now, we want to focus now on the economic systems because there is a difference between the rules of the games of how a country is governed economically. There you have basically two extremes. You have market economies and you have command or planned economies. The planned economies were the ones with the government was taking a commanding height in the economy and all. Think about Marx's book Das Kapital, where he says, okay, the factors of production, labor, capital, land, and entrepreneurship, they should be owned by the government. They should be owned by the state. They should be controlled. And in fact, how do you have price setting then? Well, supply and demand are not just by accident coming to an equilibrium. Now it's the state. No, in these command economies, in the planned economies, it's the state that plans the price and that sets, for example, if you need read the readings of Carlos Gadar in Hungary, you see that what they were doing, they were planning how much output there would be in the steel industry, there would be in Janos Kornai is the author. He has published books on how to set prices in a command economy. Now, most economies are actually mixed because we will see that the market economies, the extreme case of Colbert under Louis XIV, under Louis XIV in France, of the laissez-faire, laissez-passer strategy of complete market economy is not something that we still have. No, we have something which is in between. Now, to see the varieties of capitalism, the more extremes laissez-faire, laissez-passer economies are actually in the UK, Canada, Australia and the US. There you have the liberal market economies. They are all characterized by high stock market capitalization. What does that mean? That means that a lot of the companies are publicly traded. And so the stock market capitalization is actually the price of the stocks times the number of stocks in the economy. Now, in this case, you have a lot of limited liability companies, but a lot also of companies where the shareholders are minority shareholders, and so actually they are traded on the stock exchange. In another extreme are the German and Austrian companies, which have an other variety of capitalism in the sense that there is much more coordination. And these are called not liberal market economies, but coordinated market economies. So there is a lot of coordination. Typical for these type of companies and this type of market economy is that employment protection is much higher. Employment protection is low in liberal market economies and high in coordinated ones. The stock market capitalization is high in liberal market economies and low in coordinated market economies. Now, there are countries in between, such like Sweden, Denmark, Finland, so mainly Scandinavia, the Netherlands and Japan. And we see, on the whole, we see an evolution from more coordinated market economies towards more liberal market economies in the latest years. So in fact, there is still partially state ownership of, for example, blue chip firms in some of the economies. Why? Why? Because we don't have a complete market economy. In many cases, there is this correction for a coordinated market economy, which we could think of as an extensive welfare state. You have a combination here of a welfare state with a flexible labor market. And the more flexible the labor market is, the more liberal the economy is. But that means that you have in the UK this hire and fire mentality, and where less people are protected in case of bankruptcy of companies, for example. Now, if we go to the legal systems, if you think about the logical reasoning in the legal systems on the continent, the European continent, is again different from what we see in the UK. And on the continent we have the civil law, and the civil law is actually the Napoleonic law, which comes from France and the countries that were occupied by France, so parts of Switzerland, Belgium, the Netherlands. They all have this legal tradition whereby you use codes. What is important in civil law is codes and statutes. Look at this YouTube movie, which will show you the difference between common and civil law for companies. So the legal judgments are important there. So in fact, the judge is important. The judges in a civil law country lead the proceedings. The investigation is done by them. They are the investigators and they formulate the laws. So the lawyers are in that case actually less important. It's more the judge. Whereas in a common law case, as we have the system that we have in the UK, there it's the lawyers that examine the witnesses case by case, and they look at what we call precedents. Now the precedents, what has been spoken, so what have been the judgments before, are very important, and you have to scrutinize what has been decided by the jury, and the jury is very important in a common law situation. So the lawyers have a much more important role to play than in a civil law environment. So it's judicial decisions, previous judicial decisions that are the guiding principles of the law. It's more the spirit of the law than the text of it. In the civil law it's more the text, in the common law it's more the spirit. So if we look into the legal systems, it's important when you're going to operate in a certain country that you know which legal systems are at place. And so the historical origins are of course important there. So English law is much more customary law. So the people that wrote the legislation, they actually in common law, they went from city and hamlet to hamlet and village to village in the UK to see what were the customs, what were the habits, and they wrote it down. Whereas the Roman law was much more centralized. It was the Napoleon Bonaparte who decided what were the codes and what were the statutes, and that had to be followed by the people everywhere in the country and in the countries that were conquered by Napoleon. So in fact this is a much more centralized system, and it dates back from 1804 when Napoleon was the emperor of a big part of Europe. Now the primary sources here, as said, are the codified books of law, and the scholarly conceptualization of the lawyers at academic institutions, but also in practice. Whereas in the common law in the UK, you have the statutes. They wrote basically up the customs, and the court decisions were very important. What has been said before? What are the precedents here? Now the court proceedings, so you see here in the civil law, in the Napoleonic environment, that the judges lead the procedures, but so including asking questions and taking decisions. The judges are important investigators, whereas the judges in a common law, they are just arbiters. It's the lawyers that have a big say, and the lawyers dominate all the proceedings in the US and UK. If you look into documentaries or you look into typical soap series on legal aspects, you see that it's a fight basically between juries. The juries are the decision makers, and they base themselves upon the plaidoyers of the lawyers, and the lawyers are very important rather than the judges. Now the business practice, of course, this has an enormous impact on business practice. In the civil law in the European continental countries, you see that contracts and codes of practice are quite brief. When you compare to the UK or the US, traditionally there is more protection of employees, so that's again referring to a kind of more coordinated market economy if you link the legal system here with the economic system, and there is a lot of consumer protection. If you look at the European Commission, we have a lot of legislation which is lobbied by consumers. You have the BEUC, which is an office in Brussels, which protects European consumer protection. This is not really that elaborated in a UK or US context. So in a UK or US context, you have greater freedom to design the contracts, so it's not that strict. So it's free, but the contracts are quite detailed then, because there is a lot of things that are not in the contract. So you need a lot of clauses, to add a lot of clauses to fill the gaps actually in the existing legal framework. What in case, for example, I rent a college in the UK, in London, for my daughter who is a student there, and in fact if she cannot pay the rent, there is a lot of clauses that her parents will be liable and they will need to cover up for the paying the rent. So so all these elements, so the detail, the level of detail of contracts in the US and UK is much higher than the level of detail in continental Europe. And you need, and we extensively, if we are not honored, if our obligations are not honored, there is an extensive use of lawyers, even if your child is suffering from a low intelligence coefficient. People would, in the UK and US, they would sue the gynecologist because maybe there was an error made during the time that the mother gave birth. This isn't to give you an extreme example, but this shows you to a large extent how detailed the contracts must be in the US and UK. And I talked to many people of the investment promotion agencies, among others, Flanders Investment and Trade, for example, and they told me that, in fact, you would be surprised how many European companies are not well prepared to do business in the US because they underestimate, for example, product liability. That is very important for American legislation. So as an American company, and you need to add, for example, if you sell a lawn mower, if you sell a lawnmower, you should add a booklet with all the typical specificities of how to use it, because otherwise you are not. So to show that you will be not responsible if people use the lawnmower in a bad way, and if they cut their fingers, so as an example, which is of course very terrible, but then the American company will prove that it was said in the booklet that you should not use it improperly. So that is a difference in legislation with a lot of European habits. Now, legal tradition, so you should, before you are going to operate in a certain country, you should check which laws are applicable in which countries, and in fact that's quite important. And there are a lot of sources: introduction to comparative law, European law, international private law. So for example, if there are companies or individuals that interact from different countries, which law is applicable? And there are there are multiple legal traditions. So here you see that the civil law, of course, the French Code Civil is, for example, applicable in the French-speaking African countries, which used to be colonies of France, whereas the colonies of the UK, the former British colonies in Africa, they have English law, but that English law is not completely the same as what you have in the UK. So there is again a mixture with local customary law. So that's important. If you operate in these countries as a business person, you need to investigate what is actually applicable. As always, the Scandinavian countries are a bit in between. They have a civil law version, but which is typical Nordic. Same goes for Germany and Japan. And Japan is in many cases following the German tradition. Korea, Taiwan as well. So which is not completely the civil law again. So you, again, as an economist, you need to look and scrutinize for the details if you're signing contracts with your employees, with your suppliers, with your clients in these countries. What is also important to know is to investigate the Islamic law if you're operating with countries such as Iran, Libya, Morocco, Saudi Arabia, because this is again another tradition that is quite different from what we know while operating in civil and common law countries. Now I want to start debating some issues that are quite important. So first debate is a debate on to what an extent do we have enough protection of intellectual property rights when operating internationally. Now, we know that there was this TTIP, the Transatlantic Trade and Investment Partnership, that negotiations started back in 2009. In 2013, this was put on hold. There was the CETA, there was the agreement between Canada and the European Union a few years ago as a kind of trade and investment partnership. But there are a lot of problems also in the negotiations between developing and developed countries, among others on intellectual property. The question is, what is this intellectual property? Now, I give you 5 categories. The Peng and Meyer book only offers 3. I think it's important to add also trade secrets and the right of publicity. Because what are the types of intellectual property that need to be protected? Well, first of all, patents. Second, copyrights. We will talk then subsequently about trademarks, trade secrets, and the right of publicity. If you think about the intellectual property rights that need to be protected, first things that you probably thought of were patents. Now, the problem with patents is that they are a bit mixed, because the patents are legal rights that are awarded by your governments, by the government authorities. It could be the patent office in Munich or in The Hague in the Netherlands. It could be the patent office in the US. It's a protection for investors, for inventors, of course, inventors of new technological ideas. But the problem with these patents is that you write down everything and you file for a patent. Many people do that. I did this also together with some relatives of mine. And what you discover is that the patents are actually not only a protection of information, of your technological idea or your idea about how to manufacture a product, but it's also a diffusion of knowledge, because you, in detail, you describe how your invention is something particular and why it needs to be protected, because it's quite original. Now, it gives you, the patent in theory should give you a monopoly right to use that idea. You can also license it. There are many companies that licensed by, so the ID comes from another company, but you as a licensee, you can use it. Or it can be sold to a company, so actually, or an inventor. The inventor, it's also expensive to pay for the protection of your patent, so there are many inventors who, after a while, they sell it to a company, because then the company has maybe more financial power to keep it protected. But of course, what you see is that these patents, they need to be enforced, and we will see that that is a category of intellectual property right that is, in many cases, violated, right? There are infringements on the patent laws. Second, if you think about another type of intellectual property, think about copyrights. Copyrights are the exclusive legal rights of authors and publishers. For example, of your Peng and Meyer book, I like you to respect the copyrights, because these people invested a lot in it, and so we don't want to Xerox to copy it. It's a question, of course, some of the money is going to the publisher, the editor, and another part of the money is going to the writer, to the author. It can be the writer of a book, but it can also be a photographer who puts a picture somewhere on a website, or it can be a piece of software by an ICT developer or a design, and it can be a chip, an ASIC design engineer who wants to protect a certain chip that can be applied in certain products. Now, all these things you have copyrights for, and in fact, you don't want people to infringe on them. A third category of intellectual property rights are the trademarks. If you think about it, what is a trademark actually? It's an exclusive legal right of firms to use a specific name. For example, a garment is made out of wool, and the wool comes from either Australia or New Zealand, and these are there is this wool mark, which is a kind of sign for the wool coming from the sheep of New Zealand or Australia. It can be also a brand. You cannot copy that brand. There is a brand protection organization. A design. For example, if you think about Vitra furniture, the design rights are given to a company, Cassina, which can then use the Ottoman chair or typical furniture and designs of the Vitra company, which is on the border of Germany and Switzerland. Now, what is necessary, maybe I want already to show you some implications, because what is necessary to make your TRIPS, so your trade-related intellectual property rights, we have a problem with that, because there is a lot of falsifications, there's a lot of imitations that are not affordable, that need to be charged, right? And people need to pay if they need to be punished for infringing on patents or on trademarks. But the problem is, how can you set up a system that makes sure that your intellectual property rights are respected? There are 4 elements that are needed. First, enforcement. If you have a patent but it's worth basically nothing, it's a piece of paper without any enforcement, then it's not good. Second, you need a certain type of education. You need to educate people. The Ministry of Economics of Belgium, for example, they teach you how you should respect patent rights, how you should respect, and also when foreign companies are doing business, they send you information about possibilities of infringement that are not allowed, right? External pressure is of course important. When companies don't react to infringements of their patents, then you don't have external pressure. It could be that someone else, actually it's not a company, but there are whistleblowers who discover that some products or some manufacturing techniques are copied by other companies. Now, if you put external pressure by your government, by competitors on these type of practices, that will lead to punishments. Fourth, you have economic growth. If you think about which countries are very sensitive to infringements on intellectual property rights, these are countries in which the property rights are not respected. In many cases, these are countries in which economic growth is lower, and they want, of course, the companies of these countries would like to advance their business practices by copying these things without realizing sometimes. You hope that they don't realize that they don't do it on purpose, without realizing that this is not allowed, because it's the result of a lot of research or a lot of creative efforts of single inventors or groups of researchers or groups of inventors within firms. Now, there is a 4th and a 5th category of intellectual property rights that we need to discuss. First, we need to discuss the trade secrets. What are trade secrets? Think of Coca-Cola. We will never know how you make what is the recipe of a Coca-Cola, Coca-Cola Life, a Coca-Cola Zero. These are types of intellectual property that are linked to a certain formula, a chemical formula, or a practice, or a process. How do you transform your inputs into a certain product, a design or an instrument, a pattern, or a compilation of information. And in fact, it's not allowed to copy these trade secrets. In many cases, they are really secrets, and so you need to rob a bank and open the place where these trade secrets are kept, to be able to do that. So it will be highly protected by a company like Coca-Cola, for example. Now, the right of publicity is in the last category. This is also interesting because publicity is also a form of intellectual property rights. It protects against the misappropriation of a name of a person. You cannot make a kind of slice, a small variation on the name of a person, or to make it sound like something which is similar to that name, just to divert the attention of people. Now, those people, if they know that their name is used for something they didn't give the permission to, their personal identity, of course, of these persons is blamed, and personal identity for commercial, if it's used for commercial benefit by someone else, this is really not tolerable. So use someone's picture, for example, on Flickr in an advertisement. Don't do it. And this was done by a certain Mr. Chang from the US in an Australian advertisement. Someone, a whistleblower, talked to him and made it public. And then, of course, there were some punishments for the people who used these things in the advertising campaigns. Now, a second debate is about corporate governance. So you can see that there is a link actually between good practices of corporate governance in a country and the institutions, the functioning of the law. In fact, when you have the board of directors of companies, that's a very legal issue. So that's also the reason why there are a lot of lawyers in boards of companies, apart from economists and engineers, of course. But what is important is that you have a board of management, you have supervisory boards, and you have then the last resort is actually the annual shareholders meetings, which can be very, very, very provocative if the shareholders don't agree with the decisions taken by the managers. But this is also a guarantee, a kind of safeguard, when you have this board of directors to monitor and to scrutinize the good governance in your company, and also the good use of the legal framework of the country in which you operate. So the corporate governance, what is it? Is actually the way, the rules by which the shareholders and the other interested parties control the decision makers, typically the managers. Now, these rules and procedures for making decisions, they, of course, these rules specify what are the rights. And so, for example, some of the board members have voting rights, and what are the responsibilities among the different participants in the corporation. What can be decided by the board, what can be decided by the managers, and what is the say of the shareholders there. And the shareholders have a kind of monitoring function. Now, the variations in corporate governance, and there are variations in corporate governance around the world, and you see that typically in some of the countries in which these corporate governance are well functioning, these are also countries in which the economic and the legal systems are quite well organized. Now, of course, we don't want to say that only shareholders are the ones that can interfere in the policy of the company. We have also other people. It's not only the stock market that should survive on the company, but there are also the people, the local employees, the people that are living close by and suffer from pollution or some positive spillovers like research results of your company, and they should also have a say in the investment behavior and other types of behavior by the managers of the company. So this is for sure, this is changing because of the evolution in corporate social responsibility that has an influence on the maximization function of companies. Now, if you look into another debate, this is the last debate I'm going to dwell upon, institutions and political risk. So the problem is that businesses prefer stable institutional environments, but they are almost never available. In each country there are political changes, and luckily so, because of course it cannot be that the political leaders, they last forever, but the changes in law, for example in legislation about taxes, the changes in legislation about employment protection and employment contracts, they of course are common, and they are actually difficult for companies sometimes to follow, because in some cases there is really political risk. Look for, if you are going to establish an affiliate, for example, in a country, you should look into the political risk of that country. What is data that are very good data are provided by the Economist Intelligence Unit, by Euromoney, by the World Bank. And then of course you have not only to look at the macro data, but also to go deeper into the data that are typical for your industry or your service sector. Now, even small changes can shift the playing field between foreign and local partners. Why? Because the local companies are in many cases much better informed about small changes because of the political system or the economic changes than are the foreign companies. For foreign companies, they found it out, it's in another language, it's another culture, so in many cases they have to find it out thanks to the collaboration of their local partners. Now, there could be more serious political risk in the case of a war, of course, a military embargo like we have against Iran now from the US. Danish investors experienced, for example, a lot of problems in Russia during the crisis between with the Crimea, so Russia basically annexing part of the Crimea against the opinions, of course, of Ukraine. And then the problem is if companies that are involved in these regions yeah, how do they need to react? They cannot express themselves purely politically, but they, of course, are the victims of some of the consequences of differences in opinion between, for example, here, the Ukrainian and the Russian government. You read the closing case Carlsberg, which is a Danish brewing company in Russia, if you have time, then you see what happens. Other sources of political risks, and that are even fiercer, are of course civil wars, like we had in the Balkan some years ago, riots or protests between for example, the protests that we had in Hong Kong in 2019, and breakdowns of public order. That's even worse if you operate in a country like this. Yeah, you should, of course, evacuate your people. That is then the extreme. But public order, for example, if there is a war or there is something that is not well organized in the country, and then you should leave and evacuate your people there. So that can cause, of course, major losses for your business, but maybe the situation is not stable enough to let people with their families live there. Now, the most extreme case is in our case. So there's the Repsol case, which is a Spanish company which is specialized in energy, and they were confronted with the situation of an expropriation of their assets in Argentina under the regime of Elisabeth Kirchner. And so I asked some questions, and I want you to investigate that case and to come to some answers on these questions. So implications for practice, if you tell it to your grandmother, I don't underestimate the level of your grandmother, but it's to talk about the chapter and to say, okay, what was really the message now if I do business in some countries, what have I learned by this, what is practical and what is not purely theoretical. First of all, when entering a new country, do your homework. I would advise you to study the situation, to study the culture, to study the legal system, to read some books about this, to talk to some local people and understand the formal institutions. Secondly, the changes are very important. If you hear that legislation is going to change, well, companies are always quicker than governments. They hear about it because they know people there and they try to anticipate. For example, if you think about a Brexit, well, companies in continental Europe are already kind of anticipating behavior. Some companies, for example, did tariff jumping FDI, and they invested in the local UK region just to be able to deliver some of their goods at a regular pace and not to be dependent on tariff and non-tariff barriers, which could be a result of a no deal in the Brexit negotiations between the European Union remaining members, the 27 member countries, and the UK. Now, another lesson you can draw from it is that when you do business in countries with a strong propensity for informal relational exchanges, such as I mentioned Congo, but there are many other countries, don't insist on trying to formalize the contract until people agree with it, because it might be a kind of offense to them to put everything on paper, and the contract might right away may backfire, right? So take into account that some people need more time. Take into account that the contracts are less detailed than maybe in your home country, but you can sign contracts and you can do good business in these countries, for sure, and I invite you to do so. Now, the most of the developed economies are supported by a lot of market supporting formal institutions. Why, I wouldn't say underdeveloped, but developing economies are held back. They are held back because in many cases still these countries suffer from weak, ineffective and market depressing formal institutions, and they don't stimulate enough the working, the functioning of the market, or the institutions are weak and so they cannot protect property rights of people. I have some of my colleagues, friends in India, for example, they tell me about this. They would like to have this in place, but it's not possible. But that doesn't mean that you cannot do interesting business in a fabulous country like India or China. Now, look at the closing case, Carlsberg facing political risks in Russia, and find out why the investment is risky. if you look into why Western European MNEs still invest in Russia, so I want to make a statement that, of course, you don't need to avoid countries in which there is a lot of political risk, but you need to know whether you have a strong relationship with your partners and that they are trustworthy, these partners. Here I have a summary, so I go over it. So critical discussion questions, some readings. What is interesting is the reading by Zweigert and Kutz, Introduction into Comparative Law, if you're interested in knowing or in the future after taking the exam. I teach for the general culture and not only for exams. So find out about the main legal systems in the countries that you're operating in. There are a lot of varieties of capitalism, and everything is based on what we call the institution-based view, and now we dealt with the formal institutions. So thanks for your attention, and you can now read the Repsol case. I hope you enjoyed this lecture as much as I did.